Our agenda will start with 3 threats to your legacy, because understanding that will help you create a trust that will address those threats. And then we'll go into the steps to creating a living trust so you can complete your estate plan and options on how you can get it done. You also have a chance to consider if working with a certified estate planner will help you complete your plan quicker and more affordably. And I'll make sure to leave time for Q&A. Great. So many of us spend our working life building this beautiful cake, our legacy to pass on to our children, not realizing they're unwanted guests waiting with forks in hand. If we don't plan properly, there might be a huge chunk missing by the time it gets to them, or they'll just end up with a small slice, or worse, by the time it gets to the grandchildren, just crumbs. So tonight, I want to show you how you can preserve this legacy, keep this cake as intact as possible. Okay? So who is trying to take big bites of your cake anyway? That's what I refer to as the 3 threats. All right. Let's start with Jane. She was a very famous actress who died in a car accident. She didn't have an estate plan. She was only 34 years old. So the state exercised the default plan. Her 4 children were split up because they had different fathers, even though Jane would have wanted her mother to raise the 4 children together. But she didn't express that in a plan, so the state took the default action. Her children were not allowed access into the, let me see. Sorry, I wish my assistant was here to help me admit these folks, but she's not here tonight, so I'm on my own. So I appreciate your patience. So her children were not allowed into the home, and even small items were locked out. Like her daughter wanted this charm bracelet, but she was denied it, and later she found out it was sold by the estate for nothing. It took 10 years for her probate to wrap up, and by that time, a little bit went to paying her debts, but most of it went to pay the probate attorneys, the court fees, and all the administrative fees, assessment fees, so that when her 4 children finally grew up, there was nothing left for them. You think this just happens to celebrity, but here is a recent article from Forbes that shows that uh, the average probate for mainstream families takes 20 months. That's almost 2 years. And it costs between 3 to 7% of your estate. So let's say you have a nice round number for your estate, like $1 million. 3% of that, which is the lowest, the low end, that means everything went smoothly, no big surprises, no family fights. So it just costs 3%. That's $30,000. That's money that should go to your spouse's retirement or your grandkids' college tuition, not to the courts. So that is the first threat to your legacy, the delay, stress, and cost of probate. Okay. The second threat is even more expensive than probate. Why do I say it's more costly than probate? You've heard of families. I'm sure you're likely to have stories of families that receive an inheritance and it broke the family up. They no longer spoke with each other. We shake our head and we say, oh, that's just too bad. But that could happen to our family if we don't understand the 3 causes of family fracture in the context of an inheritance. The first cause is probate. It's understandable, the stress, delays, fees of probate will put any families on edge. Outsiders whisper things like, oh, you did so much for your mom, or oh, you put your job on hold to, take care of the family home and things like that. And court orders are so cold without any context. But the reason you have more family breakups in probate is because probate is a ready-made venue for disputes. The judge is already there, complaint system is already built in. Hold on a minute. How do I do this? I have no idea how to admit latecomers. So I apologize to folks who came in late. Uh, waiting room, let's see. Okay. All right. So that is the first cause of family fracture. The other cause is the family home. Don't think of the family home as just another asset. It's emotional. It's Christmas mornings, it's baking with mom in the kitchen. And it's also unequal. Maybe one child stayed with mom, or another child paid for a lot of repairs in the home. And it's also illiquid. One of my clients even offered to buy out the other siblings at a fair price, but one of the siblings insisted that putting it out in the open market could fetch a higher price. So in the end, nobody got the home, and everybody was a bit sore with each other. That is a very common source. So make sure you understand what's going to happen to your family home. Okay. The third cause of family fracture is surprises. Yes, there's surprises of hidden accounts, unexpected debts, but the surprises that really have the biggest impact on family fracture is when a parent said different things to different children, or last minute changes to the will and unequal gifts, because behind these surprises is this, is the family wondering, was mom pressured? Was mom influenced unduly? So grief suddenly turns into, suspicions, and loving siblings suddenly become guarded negotiators. So these are the three causes of family fracture. And to me, that threat, number two, family fracture, is the costliest, because I would be so brokenhearted if my husband and I pass away and our children no longer have Thanksgiving together because of some family disputes. Now let's talk about threat number three. What do you think the third threat is? Threat number one was probate. Threat number two was family fracture. What's threat number three? Is it taxes? A lot of people usually guess that. Death taxes. Because it's imposed at death, but also people are deathly afraid of them. So let's quickly go through death taxes so you understand what they are, okay? First is the estate tax. It's the tax on the person who passed away. Of course, he's not able to write a check to pay the IRS. It's taken out of his estate. That's why it's called the estate tax. And the rate at the federal level is 40%. That's really steep. Fortunately, they're only after the big whales, only if you have more than $15 million. The second death tax is called the inheritance tax. This is imposed on the person receiving the inheritance. And the federal, in the US, there is no inheritance tax. You could inherit $1 million from an uncle somewhere, and you would pay zero inheritance tax. The third is capital gains tax. If you inherit a home that has appreciated highly, do you have to pay a tax on the profit of the home, the capital gain of the home? So that's the third tax. If your parents had sold a home before they die, they would have to pay a huge capital gains tax. But in the US, the person inheriting it gets a step up in cost basis, so there's no capital gains tax. This is the federal level. As you know, every tax also has a state level. So estate tax at only 13 states, only 1/3 of US states actually impose a estate tax, and they're not as high as 40%. They're more like below 20%. inheritance tax, only two states, Pennsylvania and Nebraska, impose an inheritance tax on children receiving inheritance. All other states, children are waived, or there are actually only 3 or 4 other states that charge inheritance tax on non-children. So let's see how this plays out with an inheritance that Mike received. So Mike received quite a big, sizable inheritance from his father. They live in Florida. Mike, there was a house, IRAs, stocks, life insurance, and a rental property. So all in all, an inheritance of $4.5 million. That's huge. But Mike's first thought wasn't, whoa, I struck it rich. His first thought was, I'm going to be hammered with taxes, right? A lot of people are afraid of these death taxes. So let's calculate Mike's taxes, okay? Let's start with his federal taxes. The estate tax has a $15 million exemption cutoff. $4.5 million isn't even a third of that, so 0. No inheritance tax and capital gains step up. So federal tax, 0. What about Florida state taxes? Guess what? Florida is one of the 37 states that do not charge an estate tax, so 0. And inheritance tax is also 0, and so an inheritance of $4.5 million, 0 taxes. Now, if he were unlucky enough and lived in my state, Massachusetts, which has an estate tax, okay? So here's Massachusetts. It has an estate tax for anything above $2 million. That would be an 8% state estate tax for anything above $2 million. That still brings it to, because he'll be charged 8% of the 520,000, that's only about 41,000. The reason the exemption is 2 million per person. So Mike's mom and dad could shelter $4 million and he'd only, so even if he lived in a very high state estate tax like Massachusetts, it would still be insignificant. So death taxes is not the third threat. Most people will not be hit. Most people will not be hit by any death taxes, federal or state level. And if they live in a state that has, so here are some of the states that imposes an estate tax, and their exemptions are either very high or, so only these yellow ones that are highlighted have an exemption of $3 million or lower. That's just 5 states out of 50 states. So I am here to rest assure you that death taxes is not going to hit most people. The third threat is inheritance wealth erosion. So let's say your legacy dodged probate, and it also dodged family fracture. Everyone's intact, still having Thanksgiving together, and it also dodged the taxes, and it made it intact to your heirs, whether they're children, nephews, or grandchildren. Well, a new set of risks show up. Here's what I mean. Have you heard of the lottery winner's curse? Most lottery winners lose their winnings in a few years. Some are even worse off because too much money too quickly without safeguards make you do stupid things. This can happen to our heirs as well if we're not careful. They can squander it on, cars or flashy lifestyles, or worse, hurt themselves with substance abuse. The high risk man, this is the opposite. These are heirs who feel so responsible. So with their inheritance, they feel pressured to grow it. So they get into high risk ventures, things they don't know about, and end up losing their inheritance. Are your children in high risk professions where lawsuits and professional liability are common? Their inheritance, if you give it to them outright, becomes exposed to these liabilities and creditor risk. How about potential divorce? Let me say first that inheritance is actually considered separate property, not marital property. It's just that over decades of a marriage, it's so easy for it to get commingled into marital property. For example, okay, say 1 month, money is tight. Family, went on a vacation, so money's tight. And you decide to say, hey, we need to pay the mortgage and my inheritance is just sitting in an account. I'm going to pay the mortgage with it. You do that like 2, 3 times, and now that inheritance is considered marital property because it's used to support a joint marital asset. So at the event of a divorce, half of that inheritance could walk out with the ex-spouse. Or heirs passing away. This is the scenario where this young man inherited quite a sizable inheritance from his parents, but before he had a chance to create his own estate plan, he passed away. So the state's default plan is that his assets go to the next of kin, which is his wife, who later remarried and had, her own family. So in essence, that inheritance just left the bloodline. So this is what I mean by the third risk. This data shows that by the second generation, only 30% of the inheritance is left. And by the third generation, only 10%. So my previous illustration of this cake, becoming a slice or crumbs is not really an exaggeration. You may have heard this phrase from shirt sleeves to shirt sleeve in 3 generations. That's the same idea. If there was one simple thing you could do to protect your assets, your legacy from these 3 threats, probate, family fracture, and wealth erosion by heirs, would you do it? My guess is that you would, right? Well, that simple thing is a revocable living trust. So we're at this point in the agenda now, we talk about the 3 threats. Now I'm going to show you how a living trust can protect you against the 3 threats. So a good trust is not just about bypassing probate. That's just the baseline. A robust trust also needs to preserve the family and preserve your children's inheritance. Let's talk about how a trust protects you against probate. First, I'm just going to step back and explain a little bit aside of probate that you may not be aware of. What triggers probate? It's when we die with assets in our name without an automatic transfer mechanism, because we're no longer around to sign off on the title of these assets. Think back when you bought your house, okay? That everybody got into a room, lawyers, brokers, to sign off on the title because it's so important. You wouldn't be happy with just a letter saying, oh, you now own this house. No, you want to make sure that the title has been signed off to your name. When we die and we're not able to sign off on the title, the courts have to protect us. That is what probate is about. I know it has a bad rap, but its intention is to protect our assets, to make sure it goes to the right heirs, and so on. When you have when you have a trust, it becomes a proxy. It's like another person, and you're able to transfer your assets into the title, into the trust, so that when we die, these assets are no longer in our name. There's no need for the courts to step in because the titles have already been transferred. You still remain the trustee of the trust, which means you have full power over the assets. You can take it out, you can sell it, you can buy another property, you can dissolve your brokerage account. As trustee, you still have full control of that. That is how a trust protects you from probate, by making sure that all your assets that have titles are already inside the living trust. Which is why a will does not avoid probate, because a will is essentially a letter to the judge. Hey, I want this asset to go to this person, this asset to go to that person, but the assets are still titled in your name. So the court still need to oversee that title transfer. How does a trust protect you from family fracture? Well, by avoiding probate, which is one of the big cause of family fracture. And then two, it encourages intentional planning, the process of doing the trust itself. Yesterday, I received this email from a client who said, Martha, I'm so embarrassed. It's taken me like 2 months to try to sort out what to do with certain situations, to finalize my trust. And I had to remind him, that's the point of the process of doing a trust. So you can anticipate these situations, you can think through the family dynamics. If you're not doing that now, then after you pass away, then it will fall on your children. That's just going to be so much harder. Having a trust document, having it in writing just reduces confusion and surprises. How does a trust protect the inheritance? Because a trust allows you to stagger the distribution of the inheritance. For example, you can say a quarter of the assets at age 30. So your children may all be at different ages, but when they reach 30, they'll get a quarter, and then the rest at age 40. You cannot do this with beneficiary designations. With beneficiary designations, they get it all lump sum overnight, immediately. A trust also allows you to appoint a trustee to further add another layer of safeguard and protection for the distribution of your assets to your heirs. When parents hear this, they appreciate the protection because now the children get a chance to mature and go through the school of hard knocks, a bit longer before they get their trust. And until they reach these ages, they cannot be sued. If they're sued, they have to go through a divorce or anything because they don't own the assets. They cannot lose it. You cannot lose something you don't own. So parents love the protection. But then the question is, wait a minute, before they reach those ages, can they get any support from the trust? Yes, the IRS allows and established a standard called, so before they reach the distribution age, anytime at age 12, at age 26, before 30 or 40, they have access to, you'll hear this a lot, HEMS standard. What that stands for is health, education, maintenance, and support. So anytime they have a need around health, education, maintenance, and support, the trustee can distribute funds from the trust for them. I think this is the best of both worlds because their assets are protected from lawsuit, divorce, bankruptcy, scams. But at the same time, if they have, they want to go to college, if they lost their job and they need help paying rent or looking for another job, if they have any health issues, the trust funds are there for them. So let's see what's next. Now we are going into the section on the 4 steps to creating a living trust. But that was a lot of information I threw at you. How are you guys doing? Good? Keeping up? Great. All right. When you think about how to create a living trust, it may feel overwhelming because is it something just only attorneys should do? And no matter whether you end up working with an attorney or with me or to bravely do it yourself, it's important to understand the process so you can ask good questions and get a lot more out of the process, okay? So think of creating a trust like building a house. First step is, before you hammer the first nail into the house, is to think about the key parameters of the house. Is it 2 bedrooms, 4 bedrooms? Is it an open layout and an open kitchen, bedroom upstairs, downstairs, things like that? Then you want to hire a good team to build your house. And third, you want to make sure after the house is built, it gets inspected, it gets all the approval certifications and so on. And finally, you will move into the house. And this fourth step, moving into the house, you may think like, well, of course, that's the whole reason of building a house. But you'll be surprised how many people spend money creating a trust, and then they don't transfer any their assets into the protection of the trust. Then they'll still end up in probate, and it's not the fault of the trust. Okay. So that's why this calls out for its own step, because it's quite a common mistake of creating a trust and then not funding it. That's the technical term, funding the trust. It just means transferring assets into the protection of the trust. All right, so these are the 4 steps, just like building a house. Now let's drill down, okay? Making key decisions. When it comes to a trust, what are some of the key decisions? Well, if you're married, will you be doing a joint trust, or will you be doing separate individual trusts? Perhaps it's a blended family, or perhaps it's a later age marriage where they have very separate properties. So that's a decision you need to think about. Distribution to the children. If you have children, what age do you want them to receive their inheritance? And would you allow them to be trustee of their own trust, or would you get a wiser uncle or an older cousin or something like that? And who can they direct trust assets to? Anyone they want, or only within the bloodlines? So these are just some parameters that you want to think about before you start the actual work of creating a trust, which is step 2. Oh, sorry. Successor roles is another important one. Many people think estate planning is just in the event of death. No, it's also for incapacity planning. What if you're incapacitated and you need a healthcare proxy to speak on your behalf on health issues, a power of attorney to speak on your behalf for financial issues. If you have minor children, you'll need a guardian, and the successor trustee is the person who will execute the instructions you leave in the trust. Sometimes it's a third party, sometimes it's a commercial trustee, sometimes it's your adult child if he's responsible and good with money. So these are some key decisions. The second part is then choosing the platform. If you are not going with an attorney, you want to choose a robust platform that is easy to use, and yet it's flexible and powerful enough to give you those protections, the 3 threats we talked about. Make sure it's attorney drafted documents, not AI, not something cobbled together by templates, and that it's state specific because every state has different requirements. Support is very important. You want phone support, not just chat or email, because chances are this is new for you. So it's much better if you can have someone on the phone to just, do a sanity check with. Audit check summary reports makes it much easier to review your trust, as opposed to it just gives you a quick summary of the key decisions of your trust. And definitely security is very important. Don't ever put your bank account numbers or your brokerage account numbers in your trust. This is not that type of security I'm talking about. This is security about, because you're making decisions about your inheritance. It's private, so it should be encrypted. But definitely do not put bank account numbers or balances in the trust. So that's step 2, finding a team, finding the platform to build this trust for you. Here's an example. I partner with wealth.com. It's a invitation only platform. You can check it out, wealth.com. Unfortunately, but you can't sign up on your own, because this platform is only through advisors, financial advisors or estate planning advisors. But I do want to give you a snapshot of how user-friendly these platforms have become. Most of them are, question-based. You're basically answering questions and checking off your decisions. It also has a summary where you can view your key decisions easily. Do you know why a lot of trusts sit in drawers or locked up in cabinets 10, 15, 20 years old, and they never get updated? Because no one is excited about reviewing like 30, 50 pages of legalese. When you have a summary like this, it makes it easy once a year to just quickly glance through your key decisions to see if maybe a trustee has moved out of state or there's been a new birth or new family member. It just makes it a lot easier to review your trust and make sure it's updated. You also want to make sure that the platform gives you a signature checklist like this, because every state has different requirements. A checklist like this helps you make sure that the documents are all signed, witnessed, or notarized correctly. I advise my clients this little hack to put yellow stickies on the page numbers that have to be signed, witnessed, and notarized, so that you're not at the notary's office and flipping through 60 pages of legalese looking for the right pages. That's a sure way to, miss some pages. A document that's not signed, witnessed, or notarized properly may not hold up in court. So this is a very important step. And finally, funding the trust, transferring your assets into the living trust. This step cannot happen until your trust has been finalized and notarized. Because when you do that, you're going to get a certificate of trust, which is what banks, brokerage firms, title companies, that's what they ask for when you want to transfer the assets into the trust. So this step doesn't happen till the trust is finalized. So these are the 4 steps of creating a living trust. Now let's go into the different options you have to get this plan done. So if you're not working with an attorney, then you can do it yourself, or there are online courses out there to help you. If you do it yourself, it often requires time-consuming research. You're putting all the pieces together. You're weighing trade-offs, which platform is better, what are the pros and cons. And even after all that, I think a lot of people, still feel uncertain and confused because they feel that they don't know what they don't know. An online course seems to be the answer to provide you with all that information. But when you really get down to it and you hit snags, there's no one-on-one support. There's a lot of information, but what you really need in your specific situation, you need to talk to a person with, and the software sometimes is not included, or if it is, it's a pretty basic one without phone support. I want to present to you a third option, which is what I offer. It's working with an estate planning partner. So this is an all-inclusive one-stop program, and this program includes the platform that will be doing your documents, the Wealth.com platform, includes one-on-one guidance with a certified estate planner, and all the shortcuts, cheat sheets, and resources that we've built up in a library that will save you a lot of time. The way we usually work with clients is a 4 to 8 week engagement. Sometimes life issues comes up, it could be longer, but these are the process usually. It starts with an onboarding session, a one-on-one onboarding session where we go through the Wealth.com platform. And by the end of that onboarding session, they have a draft of their living trusts, which is the most complicated document. We intentionally do not complete and finalize the trust because you just want to have a chance to talk it over with your spouse, with your adult children maybe, and just review and mull over these decisions because they have a big impact. After you finalize your trust, then we have another one-on-one meeting where we talk about trust funding. That's the process of transferring your assets into the trust. And then you actually execute it. I can't go with you to the bank to fill up a form, to title the bank account to the assets to the trust, but you will have very clear step-by-step instructions. So this is usually the process it takes, and the goal is to complete your trust, and the other three supporting documents of an estate plan. The pour over will, you might be surprised, why is there a will if we're doing a trust? Yes, a trust is always accompanied by a pour over will. It is a safety net that tells the judge, hey, if there's any asset that I forgot to transfer into the trust, my intention is to pour it over into the trust. You will still end up in probate if you forget to transfer a critical asset into the trust, but it will be smoother because your intention is pretty clear to the judge. The healthcare proxy and the power of attorney, those are the other two documents of an estate plan. So that is the goal, to complete these documents, and this is the process that we usually go through. Let's talk about costs, because cost is a real barrier for a lot of families. They when I ask them, why haven't you completed your estate plan, they all absolutely know how important it is, but oftentimes it's the cost that holds them back. Many of them have called up an attorney, gotten a quote, and then they drop the ball from sticker shock and don't pick it up until a couple of years later. So cost is a real thing. Definitely don't do anything, because probate will be the most costly, right? Even with just $1 million estate, at 3% is like $30,000. So don't not do anything. With an attorney, depending on where you live, for a full estate plan of those 4 documents, it could be $3,000 to $5,000. There are 2 do-it-yourself platforms out there that get a lot of mention. One is LegalZoom, and one is Trust and Will. They cost $500 to $600 and come with a 30 days. You have 30 days to draft it and make edits. So with a plan that includes the platform, the one-on-one guidance, and the library of resources, what do you think would be a fair price? Any volunteers? Okay, I'll share with you what my clients tell me, that after they go through the experience of the wealth.com platform and see how robust and flexible it is, and experience the one-on-one guidance from me, they say the biggest value of doing this option is that they learn so much more about estate planning. Instead of just handing it over to an attorney and then getting back a binder and trying to figure out the legalese, they felt that they've really grown in their understanding of estate planning. And when you put all that together, they say it's worth more than what you'd pay an attorney. But the fee is nowhere close to that. It is, what is the fee here? It is $795 for a couple to go through this program, and for individual person, it's $695. For attending this webinar tonight, there is a promo code. There's a $200 discount if you act by Monday, 12 p.m. Now, if you've known me from my YouTube channel, you know that I give out a lot of resources very generously. So you might wonder, like, why this deadline? If you want to give, a discount, why don't you just give a discount? Why add this pressure? Because I do see it as part of my job to nudge you along, especially when it's a reminder to me when I get emails like this. This is an email from a client that I'd worked with, and her husband passed away, and completed the estate planning. That's the second email. So in this email, this person is just really appreciative that I lit a fire under her. She knew it was important, but she just kept delaying, and she was appreciated that I finally pushed her to do it. In this other letter, it was more serious. I held my breath when I read it, because her husband passed away very soon after, Fortunately, she had just finished her estate plan. So when I read letters like this, I feel that, yes, it is my job to just encourage you to get this done. You will never go through probate. It's your family who will go through probate. And having this taken care of is such a big gift to your family. So with the $200 discount for a couple, it's now $595, which is, you remember, is just a little bit more than the trust and will and LegalZoom without any one-on-one support. And for singles, it's $495. Let's see what else. I also want to keep giving you an incentive to act with these bonuses. The first bonus is the estate plan checklist. I've had clients ask me over and over again, help me decide how to choose a healthcare proxy or an executor, or what assets belong in a trust and what assets don't. So I finally put all that together in this 53-page ebook so that it will help you save time if you need to make those decisions too. That's bonus number one. Bonus number two is, instead of just giving you 30 days to finish your life plan, there's no limit. I was talking with this client, and he said, I bought the trust and will twice because twice I let it expire before I open the software. Okay, that will not happen here because your access is unlimited, as long as I'm still partners in a partnership with wealth.com. So what does that mean? 2 years from now, if you change your mind about a trustee or about a beneficiary, you can simply log back into wealth.com and make those changes. You don't have to call an attorney. You don't have to wonder what an attorney will charge you. It's all in your hands. That's bonus number two, lifetime unlimited edits to your documents. Bonus number three, it's a complimentary wealth.com account. So I'm sure you have friends who still think a will bypass probate, they just haven't gotten their estate plan done. You can give, with this bonus, you have a complimentary wealth.com account you can give to a relative, a neighbor, a friend, a cousin, and they will have the same access to all the resources, worksheets, and the bonuses and lifetime unlimited edits. They will not have a one-on-one meeting with me, but they'll have everything else. The one condition is that you can only do this after your own plan has been completed, because I don't want you to get distracted. So when you've completed your plan, this is a gift that you can give to someone you care about to make sure they also will bypass probate and protect their legacy, protect their estate for their family. So to sign up with this program, you would go to this website, estateplanpartner.com, and oh, I'm sorry, I didn't update the deadline. Estateplanpartner.com. This is how the website looks like on the left. Maybe I'll move my head here. This is what it will look like. And you will choose whether you're signing up on the individual plan or the couples plan. When you make that choice, it will take you to a payment page. Don't forget to enter the discount code TRUST200, because that will take off $200. And then after that screen, you will be asked to set up an onboarding appointment with me. In this one-on-one onboarding appointment, we will complete the first draft of your living trust. Our goal is not just to keep giving you more information. Our goal is to get this plan done. Okay, So here's a summary of it, estateplanpartner.com. Here's the cost, the promo code. What you get is one-on-one guidance with me, not just one-on-one Zoom meetings, but anytime you have a question, don't be stuck by yourself. You have a one-on-one guide that you can email, set up a Zoom meeting, and it also includes the wealth.com platform, unlimited edits, and for as long as I'm still in partnership with them, you can go in and make changes, and the library of shortcuts to help you save time. The bonuses include the checklist book, the lifetime unlimited edit, and a complimentary wealth.com account that you can give to someone you care about.